Hello, my name is Melissa Worth and I am a solicitor helping businesses and private individuals to resolve their commercial disputes. Each week I do a short 6-minute-ish vlog about a recent case. On the 15th of January 2021, the Supreme Court handed down judgment in the COVID-19 business interruption insurance test case. Financial Conduct Authority against Arch and others, and the citation is UK SC1. The defendants were various insurers. The Financial Conduct Authority, or FCA, is their regulator. The FCA wanted to determine whether losses resulting from COVID-19 were covered under the terms of various business interruption insurance policies. The FCA issued a test case in the High Court, and during those proceedings, 21 sample policies were considered. The FCA, together with 2 action groups, submitted the arguments on behalf of the policyholders or the insureds. Many of the insureds were small businesses. The High Court judgment was handed down on the 25th of September 2020. The FCA was largely successful, and this was welcome news. However, 8 of the defendants, as well as the FCA and one of the action groups, wanted to appeal the decision for a number of reasons. The appeal was a leapfrog, which means that the case was allowed to bypass the Court of Appeal and proceed straight to the Supreme Court. The Supreme Court judgment is very long, and so I can only scratch the surface here. The Supreme Court categorised the various issues into 5. The interpretation of the disease clauses, the interpretation of the prevention of action clauses, causation, the trend clauses, and finally the pre-trigger losses. The court also looked at the implications of the 2010 case of the Orient Express. I'm going to take a little look at the business interruption losses in respect of the disease clauses, because this is a point which I'm regularly asked about by my clients. A disease clause provides cover for business interruption loss if the loss is caused by an occurrence of a notifiable disease within a set distance of the insured's premises. The wording looked at the Supreme Court was as follows: any occurrence of a notifiable disease within the radius of 25 miles of the premises. Notifiable disease was defined as illness sustained by a person resulting from any human infections or human contagious disease, an outbreak of which the competent local authority has stipulated shall be notified to them. The insurers maintained that this clause would only kick in if it could be shown that the losses suffered by the insured actually resulted from the disease occurring within the 25-mile radius. However, it would be extremely difficult for an insured to prove that any losses was because of an occurrence of the disease within the 25 miles, as opposed to the government's response to the pandemic in general. The FCA argued that as long as the disease was present within the 25-mile radius, the policy should cover the business interruption losses suffered, resulting from wherever the disease occurred. The High Court agreed with the FCA. The Supreme Court formed a slightly different view. It held that an insured peril was an occurrence of the disease within the 25-mile radius and not anything outside of that area. However, it also found that cover for business loss was not restricted to interruption relating to the disease only within that 25-mile radius, and that there is potential for a notifiable disease to affect a wide area. Beyond that, the Supreme Court held that the wording did not provide cover for instances of COVID-19 outside of the relevant area. But in respect of causation, the Supreme Court held that to demonstrate that the interruption to the business was caused by COVID-19, it was enough to show that the loss resulted from the UK government's restrictions, as long as the government was acting in response to at least one case of COVID-19 within the geographical area covered by the clause. Therefore, even though the Supreme Court's view of the interpretation of the wording differed, the overall result for the insureds was the same. As I stated, this was just one of several issues dealt with by the Supreme Court in the lengthy judgment. The key takeaway point is that the FCA and the other interested parties acting on behalf of the insureds were successful. This is great news for businesses seeking to rely on the business interruption insurance policies in respect of losses suffered because of the pandemic. If you are a business needing help with discussions with your insurers relating to the points raised in respect of the FCA test case, please do get in touch. And as always, if you have any query or comment in respect of my vlogs generally, I would love to hear from you. Many thanks.